for those who doesn't know me, my name is Venkat Komineni. From Arjuna here. So ఇది యాక్చువల్గా ఈ వీసా బులెటిన్ అక్టోబర్ 2020 వచ్చినప్పుడు, సో దేర్ ఆర్ సో మెనీ పీపుల్ లైక్ రీచ్డ్ అవుట్ అండ్ దెన్ దే హ్యావ్ సమ్ క్వశ్చన్స్ అండ్ స్టఫ్ లైక్ దట్. So then we shared like Thana and other organizations who conducted these meetings. But however, still the lot of community members, they have questions. So, and moreover, this immigration thing is very close to my heart. So, because as Satish and other people knows, like just, so my PhD subject is like the American immigration for Indo-Americans for green card. So I think just I understand the difficulties, like just what people are going through. And so before I go, and we have Satish Kosuri on this call, like he's the IT professional and as well as small business owner, and also the very active community activist. And so more than all that, like just he's a good human being and a friend. So he's going to introduce Bhanu garu to the members here. Go ahead, Satish.
Yeah, thanks, Andy. Thanks, Venkat garu. And thanks everyone from Arizona Telugu Association. And Arizona Telugu Association, this is not the first time community, it is, though even though we memundedi Arizona lo, Venkat garu was leading the community efforts all over US anamata. అది వన్ బేసిక్ థింగ్. ఇంకా మనము భాను గారి గురించి చెప్పాలంటే హిస్ లాస్ట్ నేమ్ ఈజ్ ఇంద్ర అనమాట. అంటే ఇంద్ర అంటే ఎవ్రీ వన్ కెన్ అండర్స్టాండ్, సో కెన్ రిమెంబర్ అనమాట. సో యూ కెన్ రిమెంబర్ హిమ్ విత్ దట్. భాను ఇంద్ర గారు, హీ హ్యాస్ సెవరల్ ఇయర్స్ ఆఫ్ ఎక్స్పీరియన్స్ ఇన్ ద వేరియస్ ఆస్పెక్ట్స్ ఆఫ్ ఇమిగ్రేషన్ యాజ్ వెల్ యాజ్ ద బిజినెస్ ఇమిగ్రేషన్ అనమాట, రెండు అలాగనమాట. అండ్ ఆల్సో హీ గ్రాడ్యుయేటెడ్ హిస్ మాస్టర్స్ లా డిగ్రీ ఫ్రమ్ I think Iowa నుంచి గ్రాడ్యుయేటెడ్ అయ్యారు అనమాట. అండ్ ఆల్సో ఈ ప్రాక్టీస్ లా ఇన్ ద స్టేట్ ఆఫ్ న్యూయార్క్. ఇన్ అడిషన్, యాజ్ అన్ అసోసియేట్, హీ వాజ్ ఆల్సో ఇన్వాల్వ్డ్ ఇన్ వేరియస్ కేసెస్ ఆఫ్ బిజినెస్ ఇమిగ్రేషన్, ఫ్యామిలీ ఇమిగ్రేషన్ అండ్ ఇమిగ్రేషన్ లిటిగేషన్. అలాగంటే ఇట్ ఇస్ రిలేటెడ్ టు అసైలం కానీ, సిఏటి రిమూవల్ ప్రాసెసింగ్స్ కానీ, బిఏఏ కానీ అలాగా. అండ్ భాను ఇంద్ర గారు ఈజ్ వెరీ పాపులర్ ఇన్ ద తెలుగు కమ్యూనిటీ. దీంట్లో ఇమిగ్రేషన్ సెమినార్స్లో, ఇక్కడ మీరు ఏ వెబ్సైట్లో చూసినా భాను ఇంద్ర గారి నేమ్ ఫస్ట్ కనిపిస్తుంటుంది, సెమినార్ బై భాను గారు అని. And thank you everyone for accepting this invitation and helping our communities grow together. Thanks, and thanks Bhanu garu, thanks Venkat garu.
Thank you, Satish. Thank you.
So, yeah, just want to interrupt once. I'm recording this session, so I hope no one has any objection for that. Just let us know if anything is there.
No, I'm good.
When you're recording, just want to make one disclaimer, Andy, because this session is just for the informative purposes only. This one does not create any attorney-client relationship, or any information discussed in this is not pertinent to the attorney-client privilege. This is for general awareness purposes about immigration law, and this information can be used, disseminated for general awareness purposes basically.
Yeah, sounds good.
Thank you, sir.
Okay, Bhanu garu. So yeah, just I think if we can start with this visa bulletin October 2020. So you might got a lot of questions so far, and then just general awareness for the people, what it is, and then just what is so special about this. So just if you can start with that, like we collected some questions, and then we will start with that later.
Definitely, Venkat garu. And the special about October visa bulletin is basically it's actually kind of a relief for many people who are from India, who were born in India and waiting in the US to adjust their status as permanent residents. There are hundreds of thousands of people from India are waiting in the US to file for adjustment of status, even if their I-140 is approved long time ago, few years ago, like 10 years ago, 7 years ago, 8 years ago, because the immigrant visas were not available for them, therefore they cannot file adjustment of status. Before this, if you can mute all everybody, basically it will be really good for me. I'm getting a lot of disturbance on the back end. Sorry for that. And thank you very much for accepting my request. Really appreciate that. And see, I believe everybody in this group is aware of actually what the business immigration is all about, how the visa number allocations and the priority dates work basically. And but however, I would like to talk a few basic thing about that so that if anybody is a novice in this group or does not know much about that, they'll have a basic idea why we have such a backlog in visa numbers or issuing green cards to the people basically. Why they have to wait, why this is October visa bulletin is so significant for the people, especially for the people from India, and how it is important, how beneficial it is for our community. I just want to give a brief introduction, brief discussion about that. And as we all know that there are two types of immigration usually happens in this country besides uh, humanitarian consideration immigration, right? There are those basically two types of immigration or business immigration and the family-based immigration. Business immigration means if you have a job in the US, you will be allowed to work in the US by getting a green card sponsored by your employer. Usually there are five categories in employment-based category, which is EB1, EB2, EB3, EB4, and EB5. EB1 is basically meant for the extraordinary ability people where they have a very high-end qualifications, basically maybe like a national award recognition, all those things. We all know how these categories works and everything. And the whole problem is these visas are not unlimited. These employment-based immigration visas, immigrant visas are not unlimited. They are basically limited. They're limited to up to 140,000 visas per year. In that 140,000, basically, it's not only the one employee who's actually working for the employer, but also their family members are also counted towards the visa numbers if they're applying for the green card for the entire family. Therefore, they are very limited. 140,000 is very, very limited number of people who can get a visa in every year. And also, it's not like whoever applies for a green card in that year, they're going to get a visa allocated to them. And the countries, and the statute requires, there's a per country limitation on how many visas, employment-based visas can be given in a year, basically, right? We all know that limitation is 7% of the total number of employment-based visas that are available can be allocated to one single country. That means 7% can only be allocated in a year for Indian nationals. That means people who were born in India, irrespective, they may have a citizenship with Canada, they may have a citizenship with the UK, they may have a citizenship with Australia, but if they were born in India, they are subject to that 7% allocation that has been allotted to the Indian nationals, basically. Based upon the country of birth, their immigrant visas are allocated to the individuals. Therefore, it's very important that we basically file our immigrant petition, that is basically PERM application or I-140 petition, if that doesn't require PERM application, as early as possible, so that you are in the queue as early as possible, you know? And that's what happened with lots of Indian nationals who are in this country working on H-1B visa or L-1 visa or some other working visa, that they filed their immigrant petition that is either I-140. I-140 is basically, but they're waiting in line because they could not file adjustment of status application because visa dates are not available for them. That means visas are not available for them. And one cannot file for adjustment of status in this country to seek a permit to become a permanent resident if visa numbers are not available for them. That's why the visa bulletin plays a huge role to determine who actually gets visas, who won't get who are eligible for the immigrant visas in the particular month or particular year, basically. And that's where visa bulletin comes into a really powerful and very important one, basically. This visa bulletin is actually published by the Department of State, not by the immigration, not by the USCIS, not by the Department of Homeland Security, but it's by Department of State, basically. They are the ones who actually are responsible in operating consulates abroad or embassies abroad, and they are the ones who determine who can become permanent resident in the US, who can be allocated, for whom we can allocate the green card, immigrant visa to them, basically. That's a complex procedure which is inside, which is very, in reality, it's very simple, but it's a complex procedure which they have to follow, okay? So that's how it is. So every month, what happens is Department of State actually publishes a visa bulletin and tell basically these many individuals, if these many individuals who have a priority date of particular this date, they're eligible to file adjustment of status applications in the United States, basically. Usually from 2015 onwards, the visa bulletin has two charts basically. One is final action date, other one is filing chart. Before that, visa bulletin used to contain only final action dates. That means that is the dates where if your priority date is belongs on or before of that date, you'll be eligible to get a green card or eligible to file a 485. That's how it used to be in the past until 2015. But after 2015, USC, Department of Homeland Security, said because of huge backlog is going on, basically then Department of State and Department of Homeland Security come together and they decided to release the filing chart basically and also final action dates for the visa bulletin. That means if the Department of Homeland Security decides that they're going, based upon the demand of the work they have, based upon the workload they have, and based upon the visas available, basically, if they want to accept the cases, basically adjustment of status cases, they should be able to accept adjustment of status cases based upon the filing action dates. That's why Department of State start publishing two charts basically in the visa bulletin from 2015, that is the final action date and also filing action date basically. Now, usually USA is always used to accept final action dates for the employment-based category. That means USA is to say that if your priority date falls within the published date of the final action dates in the visa bulletin for the particular month, you are eligible to file adjustment of status. However, for the month of October, USC has said that they're going to accept adjustment of status application if your priority date falls within the dates mentioned as per the filing chart rather than the final action date. That's a very significant change basically because the filing chart actually moved the priority dates, acceptable priority dates significantly forward. That means almost 5 years than what it has been for the month of September, basically. In September, the priority date for EB3 category, employment-based preference 3 category was 2010 final action date. Even now also, final action date has been 2010. However, the filing action date has been moved till 1st January 2015. And also, the priority date, which I'm talking about priority date, I just give you a basic introduction about the priority date. What is a priority date is? Priority date is basically the day your labor certification has been filed with the Department of Labor, or the day your I-140 has been filed with the USCIS if that I-140 does not require labor certification. For example, if it's a national interest waiver petition or EB1 petitions, they don't require labor certification. So that is your priority date. So now, because these dates have significantly moved forward to January 1, 2015 for EB3 category in the recent visa bulletin, and for the EB2 till 13th May 2011, it's basically allowing thousands of Indian nationals, actually I would say hundreds of thousands of Indian nationals, to be able to file adjustment of status application until 1st January 2015 if they have a priority date in EB3 category as of on or before January 1, 2015. But what happened is basically is most of the Indian nationals basically have their I-140s were filed in EB2 preference category from 2010 to 2020. Many of them are filed in EB2 category because they qualify, they have a higher education qualifications, like they have a master's degree or a bachelor's degree plus 5 years of experience, and the positions requires those requirements. So employers can choose whether to file it in EB2 or EB3. And because those are the position requirements, many employers actually file those petitions in EB2 category, because at the time when they file in EB2 category, the dates were moving forward for the EB2 category quite faster than the EB3 category than at the time when they filed for the EB2 categories. Because now there are so many petitions have been filed in EB2 category. Now there's a lot of backlog in EB2 category. So those dates haven't moved forward that much, but EB3 category has moved a lot. Now, because of this, a lot of people were asking us, Venkat Karu and Satish Karu in our office, basically, how we can take advantage of this forward movement in dates, right? And basically they're asking us, they're telling me that, sir, my petition was filed in EB2 category. I have a priority date on January 1, 2014. Whether I'll be eligible to file 485, taking advantage of this movement, forward movement, and the filing action date, filing chart date, which USA has actually prescribed to use for the month of October. We were telling them it is possible to do that if your employer is willing to downgrade your I-140 petition from EB2 category to EB3 category, using the same labor that has been already filed with EB2 category, and then you can concurrently file 485 with that EB3 I-140. Okay, and downgrading process is not that complicated because, as I said, the statute requires and the law says that it is always an employer's choice to process I-140 petition in EB3 category or EB2 category. It is not the USCIS which will determine that your case will be adjudicated only in EB2 or your case will be adjudicated in EB3. It is the employer who asks the USCIS to adjudicate the I-140 in either one of those categories, EB3 or EB2 basically. Now, so there is an advantage for all of you to downgrade your I-140s. If your priority date falls in I-140s from EB2 to EB3, if your EB2 I-140 priority date falls between 13th May 2011 till January 1, 2015, you can file for downgrade I-140. Along with that, you can file for concurrent 485 concurrently. And a lot of people ask me, is there any issues if I downgrade? What happens to my EB2 I-140 if I downgrade, basically, right? Actually, your EB2 I-140 remains intact. It is not disturbed. It is still valid. Unless your employer withdraws that one, it is still valid. So if something tomorrow goes wrong with the EB3 petition, you always have a backup with EB2 petition, which you can use to get your green card in this country. You know, so if there is a possibility for you to downgrade to EB3 and file your I-140, along with 485 concurrently, I would advise all the people who are listening in this call to do that if they're planning to file their adjustment of status. And that is the significant. This forward movement is significant because now hundreds of thousands of people will be able to file for adjustment of status application, which actually allows them to become employer free to maintain their immigration status. Now, why I would say the employer free to maintain their immigration status is because 485 filing allows you to apply for employment authorization document, which basically has no restrictions for whom you can work with employment authorization document. You can work, you can do business, you can do everything basically. And also after filing 485, and if I-140 is approved, if 485 is pending for more than 180 days, you can actually port your employment to another employer for a same or a similar position, or to a self-employment also to the same or a similar position. Therefore, filing 485 is a very significant step in your immigration process in the United States. So it's important for you to take that step and file 485 if there is a possibility for you from October 1, 2020 to October 31, 2020. If you can file independently 485, you can do that. Or if you have to downgrade your I-140, you should downgrade your I-140 if your employer allows you to do so, and then file 485. That's my humble advice, Satish Garu and Venkat Garu. You know?
Okay, Andy. So thank you so much. Like just explaining about that. And now like just we are getting a lot of questions, and we collected all of them in sequence. Yeah. So Radhika is going to ask those questions, and then so if we can try to answer those, right? So I think then I think that would be good.
Sure.
So is that okay, Bhanu?
Yeah, I'm okay, Venkat Garu. Yeah.
Okay. So Radhika Garu, please go ahead.
Thank you, Andy. Thank you, Bhanu Garu. So the first question is, what happens if EB2 to EB3 downgrade I-140 is rejected? Can I still keep my EB2 I-140, or my entire green card process is rejected?
You can still keep your EB2 I-140. Your entire green card process is not rejected. Your EB2, which is already approved, is still intact if something goes wrong with your EB3 I-140 petition.
Okay, thank you, Andy. Second question is, can we switch company after filing the 485? And if so, should we start the entire process again, or can we port the green card?
You should be able to port your green card after 180 days of filing your 485. There should be, your 485 must be pending at least for 180 days for you to port your green card, basically. Otherwise, you cannot port your green card. In case, for example, let's put this way, you file your 485 tomorrow, basically, and then, on October 1, before 180 days, if you try to port your green card, And if your employer withdraws your I-140, then you are in trouble, basically. But if your employer does not withdraw, at least for 180 days after filing your 485, even if you port before that, you're okay, basically. So my advice will be is that you have to wait, it has to be at least 180 days pending for your 485 to port your green card.
Okay, thank you, Andy. And this next question is, are there any restrictions on changing titles after applying for 485?
No, not really, not really. If you can establish that positions are same or similar, if the job duties does not differ more than 51% than what it has been in the new position or in the past position, you should be okay.
Okay, so the next question is, I don't know if it's all one question, it's kind of lengthy. So he says, I need to know about the consular process for applying I-485 from India. And my priority date is June 30th, 2012, EB3 category. I'm still with the same company that filed for my green card, but I have moved back to India in December 2018 and still working for the same parent company on India payroll. Is this not possible? What are my other options?
The I-485 can be filed only by the individuals who are physically present in the United States. I-485 cannot be filed by individual who is outside the country. However, he may be eligible for consular processing. In order to do the consular processing, he has to file Form I-824 with the USCIS. Once the I-824 is approved, then they will forward his case to the National Visa Center, and then they will schedule for the interview abroad based upon the final action dates availability to issue an immigrant visa to him. And at the time, his employer still must show the intent to hire him, basically, and they have a job for him once he returns to the country in the position offered, basically. Okay, so if you're doing consular processing, you cannot port your employment to a different employer because there's no portability available if you're doing a consular processing also. Portability is available only if you're physically present in the United States and you're basically filing 485. Only for 485 portability is available, basically. So that's what it is. If you're in India, you cannot file 485. You have to file I-824 for the consular processing.
Okay, thank you, Andy. So the next question is month visa bulletin, which is the November bulletin. If the dates become current in EB2, can I withdraw, update my existing I-485 application, or do I have to pay all the fees again, or can I use the same fee?
He doesn't have to withdraw his I-485, basically. If we assume that if it's EB2 petition, it is not required for someone to withdraw their I-485 application, and when they have two petitions, I-140 in EB3 and EB2 petition with the USCIS, what they can do is basically is that if the EB2 becomes current and if the EB2 is moving faster, and if they want to process their 485 in EB2, they can actually request the USCIS to interfile their pending I-485 for EB3 category to basically to EB2 I-140 and adjudicate their adjustment of status application based upon that, so they don't have to refile again the entire I-485.
Okay, thank you, Eddie. So the next question is, can you please talk about date of filing H4 kids in relation to CSPA rule?
Yeah, actually it's a very complicated calculation for CSPA, Child Status Protection Act. I would love to discuss in private, but one thing you have to understand this is basically is that at the time of you filing I-140 petition, if a child is below 21 years of age, then they're automatically protected on the CSPA if they're not married. Okay, and the CSPA age calculation will be very different from the regular age calculation. So we have to see how long your I-140 has been pending to become dates current to file 485, basically. And all those calculations has to be done. It's a complicated calculation. I do not know whether I'll be able to explain in detail in this call. And even if I explain, I don't know whether you will understand or not. I would prefer talking in private on this issue and explaining in detail how the CSP age is calculated for somebody to be qualifying for the 485. But many of these children whom I know basically may qualify to file 485 under CSPA as of now.
Okay, thank you, Andy. So the next question is, I work for company A, B, and C. I have EB2 I-140 approved in all the three. APD 2012 January, BPD 2014, CPD 2014, both B and C not captured my oldest PD. My oldest PD, which is 2012, company revoked my oldest I-40, oldest 140 in 2018. Now can my current employer use the oldest date and then downgrade the I-140 to EB3 and file 485 at the same time?
Absolutely, yes. Because you have to understand this, even if your I-140 petition does not state your old priority date, it is automatically grandfathered by old priority date, your new I-140 petition that is filed in 2014. Okay, and it's automatic. It's not like you have to make a note or you have to request the USCIS and everything. Sometimes USCIS does not allocate old priority date to the new I-140 if there is a problem while filling the I-140 petition, if the employer fails to inform that he has a prior I-140 approved. Okay, sometimes it happens when they pre-fill the I-140 petition, employers don't take all the information from the employees, or employees don't provide them all the information to the employer. So they miss the question, which is in the form I-140, asking that, have you ever been approved I-140 petition? They would say yes to it and then provide the details of the previous I-140 petition. If they do that, then USS automatically assigns or retains old priority date for this new I-140. Most likely, sometimes what happens is I-140 also ignores. I mean, most of the officers sometimes ignore while adjudicating also, or fail to review the old I-140 petition. Therefore, they fail to provide old priority date in the new I-140 petition, but it is automatically assigned to your file. So you can basically actually, while downgrading the I-140 petition, you have to make a clear explanation on the cover letter, basically why the priority date for this I-140 is 2012 because of the initial petition, how it is grandfathered with the 2012 petition, and then you're eligible to file downgraded I-140 and 485 concurrently, basically. It's absolutely possible and absolutely doable.
Thank you, Bhanu Garu. So the next question is, after downgrading to EB3, if I-140 takes 6 months to approve, will 485 wait 6 months to get final decision?
Absolutely. 485 cannot be approved until I-140 is decided. And also, in order for 485 to be approved, your final action dates also must be current.
Okay, thank you, Andy. The next question is, my PD is January 2012 EB2. Should I downgrade or wait until EB3 final action date is in 2012? Also, my employer name changed and I moved to a different city. Will that have any impact to my previously approved I-140?
If the employer remains the same, irrespective of what their name is, basically, it should be okay. And is relocating to different city does not affect the validity of his I-140, because I-140s are filed at the principal place of business where the company is located, basically. For example, in IT consulting companies, business models, basically, when their employees work at the third-party client sites, employer actually located in one place. For example, let's assume that employer principal office is located in Phoenix, Arizona. Their employees may be working at the different cities at the different client locations, basically. But when they file the I-140 petition and when they do the recruitment to file the labor certification, it is conducted in the Phoenix, Arizona metropolitan statistical area, basically. So the petition remains valid. So him moving to a different city is irrelevant in filing 485, basically. And if it comes to his priority date of January 2012, I'm advising people, whoever is in between 13th May 2011 to January 1, 2015, if there is a possibility to file for a downgrade I-140 and apply for 485. As I said, you downgrading EB3, filing EB3 I-140 does not invalidate your EB2 I-140 anytime. It is still invalid, it is still valid and still intact, basically. Therefore, tomorrow, if EB2 dates move forward, you can always interfile this 485 to EB2 petition. Therefore, I would advise, do not lose this opportunity if you can file 485 in this month. So I would advise, yes, I would always advise to people to downgrade their I-140 and apply for I-140, I-485 along with it, because you have an opportunity to file for adjustment of status right now.
Thank you, Bhanu Garu. The next question is, my priority date is 2012 December in EB2. I'm sorry, I think I read that question already. Oh no, it's a different one. My priority date is 2012 December EB2, and I'm with the same company. Now, if I downgrade to EB3 and file both I-140 and 485 together, what will happen to my EB2 I-140? Will it get null after EB3 I-140 is approved?
No, it won't get null. It is still valid and it is still intact. And that means you have two I-140s. One is in EB3 and other one is in EB2. Simple thing is that.
Okay. Thanks, Andy. So the next question is, my mother's name's spelling is different in my birth certificate compared to her passport, which is her ID. Is there any place we have to give parents ID to prove their birth date?
No, not really. I mean, basically, if the name is spelled differently in your passport, your mother's name, and in a birth certificate, they may question basically whether she's the same person or not. But in India, usually we have a tendency using initial for the last name rather than the full name, basically. And if that is only the discrepancy you're talking about, you're absolutely fine. Nothing to worry about.
Okay. Thanks, Andy. So the next question is, will there be an impact on approved EB2 I-140 if EB3 I-140 gets denied during downgrade?
No, no impact.
Okay. So the next question is, my employer saying dates moved to get more money by the fees that we are going to pay, and this is a scam to kick H-1B people out. I'm sure this is not true, but I just want to confirm on that.
Well, I mean, there is half-truth to it. The half-truth is basically, yes, USAS needs money, okay? And they need money, basically, and this is an opportunity for them to get that money to run their operations, because USAS can only run its operation based upon the fee they collect from the applicants or the petitioners that are seeking immigration benefit. But other statement which is in that is basically preposterous, is how it's kicking out H-1Bs by filing 485s with the USCIS. That means unless USCIS denies those 485s, that means it's basically telling indirectly that USA is going to deny. And I don't know how, from where he got that conclusion or she got that conclusion. It's basically preposterous by saying that, yes, USCIS do require money, and that's the reason why you are filing cases with them. That's the reason why they basically adjudicate your cases based upon the fee. That's only the way they can run their operations, by collecting fees from the people. They don't get money from the Congress. They don't get money from any other agency. The money comes from them to run their operations is from the fees what individuals pay to the USCIS.
Thank you, Andy. So the next question is affidavit enough if applicant does not have date of birth certificate? Do I need to submit date of birth and medicals now, or can it be submitted later?
They both can be submitted later. You will get an RFE basically, okay? And if it comes to the first part of this question, basically is that only affidavits are enough? Maybe not, because we need to have some other document from the government, like a non-availability certificate or a 10th class certificate or some other secondary evidence along with the affidavits to prove that you are the person who's actually seeking adjustment of status is the one and you same. You're not using some other's identity to seek adjustment of status. And that's the reason why you need to provide proof that you were born in a particular country on a particular time and particular date.
Thank you, Andy. So what is the next question is, what is the order of processing the applications? Is it first come, first serve, or priority date?
Both priority date, and then look into the first in, first out basis. Basically, your priority date has to become current, and also in the order of preference of you filing your cases, they're going to adjudicate the case.
Okay, thank you. So the next one is IB3 I-140 priority date on January 2013. Later, the same employer filed EB2 with the same priority date.
Mm-hmm.
Now I am on H-1B extension using the EB2 approved petition.
Okay.
My questions are, can my employer go ahead and apply AOS using EB3 now? And is in the future, is it possible to use EB2 if visa numbers available earlier for it?
Yes, for both. Yes, for both. I mean, because employer still keeps his EB3 petition intact. If he has not withdrawn that one, yes, employer should be able to go ahead and file, and he should be able to go and file 485 adjustment of status applications. And tomorrow, if EB2 date becomes current, and if they're moving forward, he can request the USCIS to interfile that 485 to EB2 petition. So answer is yes for both.
Okay, thank you, Andy. So the next one is, do we need to file I-765 along with I-485? Also, do we need to file both 485 and 485J?
You need to file 485 and 485J. Filing an EAD and advance parole is an option for you, basically. But I always advise to file those things because you never know what happens with your employment. So it's better to have those two on a safe side.
Okay, thank you, Andy. So the next one is, can I have advanced payroll and H1 without EAD?
Yes.
Okay. So the next question is, can EB2 to EB3 downgrade and filing of 485 possible outside the US while the same employer?
No, as I said, one has to be physically present in the United States to file 485. His employer can downgrade from EB2 to EB3 anytime whether the employee physically present in the US or not. But individual cannot file 485 unless he's physically present in the United States. See, at the time of filing I-140, if he is not in the US, then obviously employer must have chosen at the time, the employee will be seeking immigrant visa at the consulate abroad. If that happens, then file automatically goes to the consular processing. Of course, if the employer chooses that he's going to file for adjustment of status in the US, then the file will not go for the consular processing. What employee has to do at the time is he has to file form I-824 requesting for consular processing, and then only the consular processing can happen. Unfortunately, people who are present, who are outside the country, cannot file 485.
Okay, thank you, Andy. So the next question is 485J a mandatory document?
Yes, it is a mandatory document.
Okay. And the next question is, my priority date is October 2015. Am I still eligible for downgrade and apply for EB3 downgrade?
He can downgrade anytime he wants to, but October 25th, which is the year?
October 2015.
2015. The point is he can downgrade to EB3, but I would not advise him to do that unless his dates is current. We don't know whether his dates are going to become current or not in next bulletin or not. I do not want him to unnecessarily do downgrade to EB3 unless he knows that he has an opportunity and ability to file 485. I will, because it's still January 2015 October, it does not mean that it's going to move forward in November. And also in November, USA is going to continue accepting the filing chart in the visa bulletin. So we have to wait for the, again, Department of State visa bulletin release and also USCIS notification pertaining to what kind of a filing chart they're going to follow. So I will not advise you to downgrade unnecessarily unless your dates are going to be current.
Okay, thank you, Andy. So the next question is, if I go outside the country, do I need to get H1 stamped if I just have advanced payroll?
No, not necessarily required. See, the point here is this basically, okay, adjustment of status is not an immigrant status, basically. It doesn't give you any immigration, legal immigration status. Adjustment of status application is basically gives you authorized period of stay in this country while your adjustment of status application is pending, you know? And so if you can maintain H1B status on the site, it's well and good basically for you because that's an immigration status in this country. But in case, if you have to travel abroad and if you don't have an H1B status in the US, then you need to have an advance parole in hand. If you have an advance parole in hand, then you don't have to go for the stamping again. You can come back and advance parole. But if you want to maintain H1B status in this country while you're an H1B in this country, and if you don't have a valid visa in your passport for H1B, then you're required to go for the stamping, irrespective whether you have advance parole or not. Because while you're entering into this country on advance parole, you are automatically considered as a parolee because your adjustment of status application is pending. You will not have H1B status because your entry into the US determines your legal status in this country or type of status in this country. So what I understood from that question, probably this is what he's trying to ask, and that's why I gave such a elaborate explanation over there.
Okay, thank you, Andy. So the next question is it mandatory to file I-485J along with the new 485 or not required, but can be filed later on?
It is absolutely required, but sometimes USS is okay if you not file it with it. The problem is, as an attorney, a law firm, we are not accepting any case if they're not going to use supplement J, because we do not know whether it's a fraudulent filing or not, because either they have to provide the consent from the employer to us or at least provide supplement J to us, as an attorney, because we need to know that they're not filing any fraudulent 485s without the consent of the employer.
Okay, thank you, Andy. So the next question is, if the EB2 dates become current, can I reverse port from EB3 to EB2 using old I-140?
Yes.
Okay. So the next one is, I'm planning to downgrade to EB3 and if EB2 starts moving, can I use my EB2 to file for another I-485 in parallel while my I-485 with EB3 is still pending?
Yes, he can do that. If he wants to file one more set of I-485, he can do that. Or he can actually just interfile the one which is already pending with the USCIS to the EB2 I-140.
Okay. So the next one is, my passport is up for renewal. Can I file for I-485 while my passport application is under renewal processing?
Yes.
Okay. So the next question is, employer A, I-140 approved, EB2 priority date April 2013. Employer B, I-140 filed and in process EB2. And his question is, can employer A file my I-140 downgrade to EB3, I-185, etc., even though he's not my current employer now? Do I need to submit any pay stubs for employer A while I'm downgrading it? Is there a risk to my already existing I-140 EB2 application with employer B if I do the above?
First, I'll answer the last part of the question, which is basically is no harm. Nothing will happen to the employer B I-140 petition if it goes through this process with employer A. First thing is that. Second thing is, employer A can downgrade and he can file 485 with it. And when he does that, nothing happens to the EB2 of employer A petition as well, basically. Third thing is that if he is working for a current employer, and if the current employer I-140 is pending with the USCIS in EB2, because the current employer I-140 automatically retains the priority date of the previous employer, basically. Okay. And because it retains automatic priority date of the previous employer, the current employer, if is willing to allow him to file adjustment of status, he can actually file adjustment of status with the current employer by filing an amendment to the pending I-140 into the EB3 category and concurrently filing I-485. He doesn't have to go to the employer A to get or file adjustment of status application here. If his current employer is also willing, he can do that. But if he wants to file with previous employer, he can do that. But filing with the previous employer does not harm, does not injure, or does not do anything with the employer B I-140 petition.
Thanks, Andy. So the next question is, if I downgrade, what is the process to use EB2 I-140 if EB2 moves faster?
It's basically, there's no process because your EB2 petition is already intact. It's already valid. If you're talking about interfiling your 485, you write a letter to the USCIS asking them to basically attach this 485 to the EB2 petition and adjudicate this I-485 based upon the priority date of the EB2 petition. That is basically simply a letter to the USCIS at the stage by your attorney or by yourself, if you're filing by yourself, can be done basically.
Thanks, Andy.
1 minute, Radhika ji. Just a reminder to everybody, please ask questions. I've seen somebody raising hands. So please ask questions in the chat and we'll be taking your question and answering them. Thanks.
Thanks, Rupesh ji. So next question, Andy. So I have EB3 I-140 with previous employer with priority date as 2014 March. I have changed employers and new employer filed perm in June 2020. Do you think dates are still valid and I can file 485 once approved my new perm?
We do not know when your perm will approve. And at the date of approving your perm, I don't know whether dates will be current for you to file your 485 at the time. It's too speculative to comment on that.
Okay, thank you. So the next question is, can I travel outside when my downgrade to EB2 and before my advanced payroll is approved, like if I plan to in the next month?
If he has a valid H-1B status, you can. But if he doesn't have a valid H-1B status and is going to be only on I-485 pending status, then he has to have advanced payroll to travel abroad. You know?
Okay, thanks, Andy. So the next question is, if work location has changed from one where perm was filed, is another perm filing required, or can concurrent filing be done for AOS and I-140 downgrade?
I did not understand what does he mean by work location, basically, because perm is, as I said, usually will be filed at the principal place of business of an employer. Okay, if the principal place of business of an employer is moved outside of that metropolitan statistical area, then you're required to file another perm, basically. But if the principal place of business remains the same, but once work location changes from one place to other place, it does not matter, because your perm is filed pursuant to the principal place of business, and your I-140 also is filed pursuant to your principal place of business. And if that is the case, and if he's eligible to file I-485, either by downgrading or straight, he should do that.
Okay, thanks, Andy. So the next question is, I have heard that EB3 will move to June 2015 in November bulletin. Is there any possibility?
I don't know where you heard. I did not hear any from any official source, so I don't know where you heard.
Okay. So the next question is, I am in I-140 approved. I switched companies. I switched company, and during the process of downgrade of EB2 to EB3 or porting this I-140, if I exit country, will this affect anything?
Can you repeat the question, please? I'm sorry.
Yeah. So he says, I'm just reading verbatim. He says, I am in I-140 approved. I switched company, and during the process of downgrade to EB2 to EB3 or porting this I-140, if I exit the country, will this affect anything?
No.
Okay. So the next one is, what is an anticipated final action date expected in October for EB3?
It's already there. Final action date. It's June 2010 for October visa bulletin.
Okay.
I don't know what it's going to be for November, but only thing we know that is that they made a note in the October visa bulletin that they're expecting or anticipating significant rapid forward movement in the immigrant, priority dates in coming bulletins, basically. But we don't know how much it's going to move in November 2020 visa bulletin final action dates unless we see what it's going to be there, you know.
Okay, thanks, Andy. So the next question is, could you please share the mandatory documents for the primary applicant and dependents?
Ma'am, there's plenty of documents. It's very difficult for me to talk on this call. Ask them to reach our office and take a consultation with our office. Very happy to talk to them. Yeah.
Okay, thanks.
Because every case is different, right?
Yeah.
Some people will have some kind of an issues, basically. If they have any criminal records or any violations, basically, we have to document those things also, basically. So it's very difficult for me to give just a list like that on this call.
Yep. Okay, understood. So the next question is, EB3 April 2012, when will they get green card? Any idea?
I have no idea. Unfortunately, I have to laugh, unfortunately, because I have no idea. I'm sorry for that, for me laughing on your question, basically, because it's not, I cannot predict. I'm not a Nostradamus, basically. I'm sorry for that.
Okay. So the next question is, EB2 and I-140 is approved, filed in 2012 November. So please suggest me how to proceed.
If your employer is willing, I would advise you to downgrade and file 485 concurrently.
Okay. So the next one is, can we travel after filing I-140 485 status?
You can travel if you have a valid H-1B status in this country, as I said, and you have a valid visa to come back to US. Otherwise, wait until your advance payroll is approved and then travel abroad. What happens is, if you travel with your advance payroll, your I-485 will be denied for abandonment, which you don't want to take that risk. But if you have a valid H-1B visa and you are in valid H-1B status in this country, or L1 status in this country, or L1 visa, or O1 visa, or O1 status, whatever visa you have, if you have valid work visa in this country and valid work status in this country, yes, you should be able to travel and come back on that valid work visa into the United States.
Thank you, Eddie. So the next one is, my birth certificate has my last name misspelled. Does this cause any issue? Should I submit an affidavit to support it?
Submitting an affidavit to support it is a good idea.
Okay. So the next one is, let's say someone downgrades to EB3 from EB2. What happens to H4 EAD for the spouse?
My point is basically is that if somebody is filing 485, you would actually get an EAD based upon the 485. Why do you want to get an EAD based upon H4? Doesn't make any sense. Because H4 EAD has restrictions. It doesn't give you automatic 180-day rule authorization to work while your H4 EAD renewal is pending. You will get an EAD based upon your I-485 and start working on that EAD basically because that will allows you to continue working while that EAD application also is pending when you file for a renewal. So it doesn't make any sense for me, somebody working on H4 EAD after they file 485 and EAD with 485.
Thank you, Andy. So the next one is USCIS verifying the credit report and financial status from the applicant's side?
Yes, basically that's what it comes under public charge benefit issue. That's what the form 944 is about. And we have to provide all that information to show that you're not likely to become a public charge anytime in the near future. Once you get a green card also, you're not likely to become public charge. But I have to give some explanation here, ma'am, before I go there, because this is a very major concern for many people right now, how it's going to impact their green cards, their future in this country and everything. You have to understand this basically is this form 944 information or a public charge benefit rule information basically is more significant if you're applying for family-based immigration in this country. For employment-based immigration in this country, there may be a lot of negative factors, but one positive factor showing that you have a job in this country, once you get a green card, actually outweighs everything else basically, okay? Although USCIS requires you to provide all this information, you should not worry about that. And your lawyers are there to help you in how to prepare your 944 and how the information is provided there also. And showing your offer of employment, saying that you're going to have a green card once you get a green card from that employer through form supplement J will suffice most of the requirement that you're not likely to going to become public charge in this country, or your family members are not likely to become public charge in this country because they're dependent upon you. Okay, so do not worry too much on this. I would advise all of you people, my humble advice is don't over analyze form 944 or its requirements. Don't over analyze. If you start over analyzing, you will miss the boat, or you'll basically misread everything, and it will make a huge mess for you. Listen to your lawyers, provide the information what they ask you, and get it done through them. That's my humble advice to all the audience in this call.
Thank you, Andy. So the next question is, my wife initial I-140 date is 2013. A new 140 is sent on June 2020 as she changed her job role with the same employer. It is not yet approved. What should we do? Can we addend it to EB3 and same time apply I-485?
Absolutely. She can file for an amendment to the EB3, downgrade to the EB3, and then file 485 together. If I were in her position, that's what I will do.
Okay. So the next question is, if I-485 is denied, can we stay on H-1B status without going out of status?
Yes, if she's continuously maintaining H-1B status without failing to maintain H-1B status, if they are continuously maintaining H-1B status while I-485 is pending, yes, they can continue on H-1B, yes.
Okay. My priority date from my old employer A in EB2 category is January 2013. Later, I moved to employer B and I ported my priority date to my new employer again in EB2. My old employer withdrew my I-140 in 2017, but he's willing to port my I-140 to EB3. can and withdrawn EB2 I-40 be revived and ported to EB3?
Yes, that can be done, but if his current employer is willing to file for him, downgrading I-140 into EB3 and it's easy to file 485 with them rather than going with the previous employer. It's of course, I do not know the dynamics, what's going on with him. He can do with either one of the employer, doesn't matter.
Okay, thanks, Andy. So the next one is, we have currently filed a litigation for the delay in getting H4 EAD for my spouse. At this time, if we also file for downgrading my EB2 to EB3, will there be any impact?
No, no impact.
Okay, thanks. So the next one is, after filing I-485, do kids continue on green card process even after the kid gets EAD and turn 21 years?
I didn't get you, sir. Can you repeat the question, please?
After filing I-485, do the children continue on green card process even after the children get EAD and turn 21 years?
Yes, it continues because they're protected under the Child Status Protection Act. Until they're married, until they remain unmarried, they're protected under the Child Status Protection Act as long as their 485 adjudication is pending. But if they get married, then they will lose the benefit.
Okay. Do we need actual birth certificate while filing I-485, or it's okay? We have secondary documents like Aadhaar card, passport, PAN card, school certificates, etc.
They have to prove why they don't have a birth certificate. So they can provide Aadhaar card, PAN card, and all these things, but they have to provide the proof why they don't have the birth certificate. That proof can be provided either in the format of non-availability certificate or affidavits from the people who are actually aware of his birth and why he doesn't have a birth certificate. Basically, affidavit must say that he failed to register at the time or his parents failed to register at the time, whatever it is, basically. That's what they have to provide. That secondary evidence means there can be several types of evidences, pieces of evidence can be added in lieu of birth certificate, basically.
Okay, thanks, Andy. So the next question is, my wife is still in India. Can I file 485 alone? And when she is back, can she file 485 again?
Yes, that is a possibility, provided the dates are current at the time. And once the dates are current, she should be able to file 485.
Okay, thank you, Andy. So the next question is, I have PERM and EB3 I-140 approved in 2011. But since then, my title has been changed from senior consultant to manager, and office location has changed from Philadelphia to Arizona. Can my employer use the PERM approved by 2011 and apply 485 now?
Absolutely, they can apply. As I said, green card is a prospective position, basically, right? If the employer is willing to hire you in that position once you get a green card, and if you're willing to join that employer in that position once you get a green card, yes, it can be absolutely be done. Okay. And second thing is also is basically, if your current position is the same or similar position, that means what I mean to say is, if the job duties does not change more than 51% than your green card position, you are absolutely okay that way also. Because as I said, it's a green card is always a prospective position. It's a future position, basically. It's a future employment. So it's absolutely fine. I mean, absolutely fine. It's between you and your employer, how you both work on that, basically.
Okay, thanks, Andy. So the next question is, please explain more on interfile when EB2 gets current while waiting on EB3 485. Should we file fresh 485, or interfile is just a switch on exiting 485? Or I don't know if it's existing or exiting.
Existing, I believe, probably.
Yeah. Is the fee same as filing fresh or different?
For interfiling, there is no fee. You're just writing a letter to the USCIS to adjudicate your case based upon the other I-140 petition, basically. Okay, you're trying to tack. It's like a tacking from one petition to other petition, right? Just like a tagging, basically, right? That's what you're doing there. You're just sending a letter to the USCIS requesting them to do that, basically. Okay, or sometimes USCIS may come back also with RFE. You have two I-140s. Which one you would like to consider also? It happens sometimes, but very rare. Basically, it's your job to basically sending a tagging letter basically to the USCIS. That's what you do. Interfile doesn't have any fees. If you want to file a new I-485, you're always welcome. You can always file that. Nothing says you cannot. But filing new I-485, obviously you have to pay new fee and everything at that time.
Okay, thanks, Andy. So the next one is, if you file 485 and it's approved, do we still need to file H-1B in the future or continue H-1B?
As I said, it's a choice. If you have a possibility to maintain H-1B status, you can maintain. If not, it's okay, because you're adjustee in this country, you can remain in this country as an adjustee.
Okay. So the next one is, can I use EB2 perm approved 140 of company A to file EB3 I-140 with company B along with I-485?
If the company B does not have labor certification process, they cannot file I-140. Basically, company B has to file fresh I-140 for him. They just cannot use the labor certification from the company A to file with company B. They can't do that.
Okay, thanks, Andy. So the next one is, after filing 485, do kids continue? Oh, I think I read this. I don't know if it's a duplicate. Do kids continue on green card process even after? Yeah, I think we had a duplicate. This is
Yes.
okay. I think this is somehow duplicates. So here's the next question. What happens if an H-1B extension gets denied after I-140 approval and priority date is July 2017?
Doesn't matter. I'm sorry, I didn't get the question. Can you repeat the question one more time?
What happens if an H-1B extension gets denied after I-140 approval and priority date is July 2017?
He's out of status in this country if he hasn't filed 485.
Okay.
Just like any other H-1B.
Okay.
He's out of status basically, and he will be accruing unlawful presence from the day his H-1B is denied, because he doesn't have any I-485 pending for him basically.
Okay, thanks, Andy. So the next question is in EB2 with priority date of December 2012, considering the downgrade to EB3, but that won't happen immediately practically. How much time we have to file the downgrade application?
You can actually file together I-140 and 485. So usually it all depends upon the load of the law firm and the load of the company and everything. Usually it's not such complicated process to file downgrading I-140, because most of the times the employer may have all the information for that I-140 because it's already filed EB2 I-140. Collecting the new information from the employee should not take much time. And I don't know what actually is asking for that, why it's complicated, why it is not, why it takes too much time. I do not know what kind of a logistics they have to go through there in their company and everything. Basically, generally, it's not such a time-taking process to file I-140 if you have all the information with you.
Okay, thanks, Cindy. And I'm not sure if you already answered this. Can I file 485 and then travel to India for H-1B stamping?
Yes. Yes, provided he has a valid H-1B status at the time of departing US.
Okay. Can I downgrade after filing 485?
I didn't get it.
Can I downgrade after filing 485?
Like, I mean, how is he going to file 485? Does he have a priority date current for him in the current EB2 category or EB1 category for him? I didn't understand that question.
So yeah, that's what he says. So I'm not sure.
Exactly. I mean, I don't know what he's trying to ask.
Okay. So the next one is, would it cause any problem to employers if I have to downgrade?
No.
Will they have any reason to say no downgrade?
I mean, I cannot comment what's there in the employer's mind, why they say no to it. Yes, there is a possibility they can say no to anything they don't want to do. See, obviously there are potential issues. Issues with the downgrading is that your employer has to say continuous ability to pay for you. But if you're working for that employer, it doesn't matter for them. It's easy because EB2 or EB3, the salary, everything is same. So they'll be able to establish continuous ability to pay. But if you're not working for that employer, if you're working for some other employer, but if that previous employer, if he's your ex-employer and he's trying to help you, then he may have to show ability to pay for you. That is something which you have to work with your employer, and most likely your employer will be able to show that ability to pay. Otherwise, why will he promise you to process your I-140, downgrade I-140? Basically, simple thing is that.
Thanks, Andy. So the next one is, what do we need from employer to downgrade EB2 to EB3?
Everything. The employer is the one who has to file that. So employer is the one who has to sign the documents and everything. So everything. And as I said, it's impossible for me to tell on this call what documents are needed because every case is different. We have to review the case as an attorneys. If you're filing your downgrade I-140, and we will be requiring to review entire your I-140 filing copy, entire financials of your employer, and your W-2s, your finances, and everything also, provided you're working for the same employer. And then we have to, based upon that, we have to make our analysis, and then we have to file I-140 downgrading. I mean, it is a process which we have to follow. It's impossible for me to give what kind of documents are required without knowing who the employer is, basically.
Okay, thanks, Cindy. So the next one is, would it cause any problem to employer if I downgrade? If I have to downgrade, will they have any reason to say no downgrade? I think this we already asked.
Already answered, yes.
Yes. So if my wife initial I-140 date is 2013, a new 140 is sent on June 2020 as she changed her job role with the same employer.
I think
It is not, okay. It is not yet approved. What should we do? Can we addend it to EB3 and same time apply 485?
Yes, they can amend it to, they can amend and file it in EB3 and then file 485 concurrently. Yes, they can do that.
Okay. Can we have two files filed, one in EB2 and the other in EB3 at the same time?
Yes.
Okay. And the next one, thanks, Cindy. My date from my old employer A is EB2 category is January 2013. Later, I moved to employer B and I ported my priority date to my new employer, again in EB2. My old employer withdrew my I-140 in 2017, but he's willing to port my I-140 to EB3. Can a withdrawn EB2 I-140 be revived and ported to EB3?
I answered this question before. I said, yes, he can do that. But at the same time, if his current employer is willing to file an EB3, he can actually file EB3 and 485 with the current employer. He doesn't have to go with the old employer, but it's up to him. I think we answered this question before.
Yes, I think we did. Sorry about that. So my daughter's H4 extension is waiting upon biometrics and has current validity end date of October 8, 2020. Mm-hmm. Can I file 485 with her as dependent while her extension process is not completed and current validity till end?
Yes. He can file 485. She can file 485 along with him as a dependent.
Okay, thanks.
CAN can.
Do you think that this dates will go back again by USCIS for any reason?
Absolutely, yeah, it will go back. But how much it will go back, when it will go back, nobody can predict that basically. Yes, they're going to go back eventually, yes, because of the number of subscriptions we have from India, the nationals we have from India who are trying to seek adjustment of status in this country. It is absolutely expected that the rates are going to retrogress even more further after usage of all the immigrant visas that have been allocated to the employment-based category for Indian nationals, basically. You know?
And do we need to get any medical tests done for filing 485?
Yes, you have to get your medicals done. It's Form I-693 has to be filled by the surgeon, basically, who's designated by the USCIS. It's always better to submit the medicals along with the I-485, but in case if you can't get enough time because of the COVID-19 and the doctors are very busy, they're not able to schedule you for an appointment, it's okay. You can submit them later because USCIS usually issues RFE for that.
Okay, thanks, Andy. This question seems familiar. This might be a duplicate. I just read it real quick. Can I travel to India for visa stamping after filing downgrade EB3 I-40 485? Do I require AP?
As I said, if he's maintaining valid H-1B status at the time of departure from this country, you should be okay.
Okay.
If he doesn't maintain H-1B status, then he requires advance parole.
So the next one is, while we are filing EB2 EAD application, is it mandatory to do medicals and submit the document initially, or can we do medicals later as well?
Ma'am, they're not, EB2 EAD is, they're applying for 485. I don't know why people confuse with 485 and EAD. They both are two different ones, basically, okay? when you apply for I-485, as I said, medicals are mandatory basically, but if you don't provide them at the time of filing, it is okay. You'll get an RFE for it, and you should be able to submit them later on to the USCIS.
Okay, thank you, Andy. So the next one is both company A and B have my I-140 approved. Now I'm working for company B. Can a withdrawn
We
EB
discussed about this, ma'am. We discussed this, ma'am. Same thing again.
same thing? Okay, so, okay, some are duplicates, so we'll have to read it. Okay, no birth certificate and no non-availability certificate. I think it's all pertaining to the same thing.
Yeah.
So the next one is my old employer willing to file my downgrade and 485, but I do not want to join after getting EAD. Is it allowed or any consequences?
Oh, that's between him and his employer. As I said, it's a green card is a prospective position basically. They can join at the time of filing 485 and working with them, or they can join them once they get the green card also. The law basically allows them even not to join them. They can port their green card if they 485 is pending for at least 180 days. But however, he has to provide a proof to the USCIS if he's porting to an employer without joining him, that it was a bona fide opportunity basically, you know. And because if they can't prove that, then obviously their 485 will be denied, because the intent of working permanently for that employer cannot be proven by the employee, you know. So it's better to join sometime with that employer and work with it. Although the regulations allow you to port your employment without even joining the employer who actually files your green card basically. Okay.
Thanks, Andy. So the next one is, will a dismissed court case affect a green card application?
It all depends upon what kind of a dismissal court case is. I have to review the file. I can't comment on that. And some cases basically can be, some people say it's dismissed, but actually it's not dismissed because it's basically after probation or after deferred actions they're called. That means they're equivalent to pleading guilty, even though they dismiss after completing the probation or after completing the deferred action basically, whatever it is basically. So we have to be very careful in answering these type of questions in this kind of forums, because we have to really review their file, what kind of a offense they have been charged with, and what kind of an offense they have been dismissed and everything else. If it's a plain dismissal, it may not affect, but we have to see all those things first.
Okay, Radhika garu, just a quick comment, and this is Venkat. I think we stopped accepting the questions, and whatever is the remaining questions, like we will go through that. So yeah, so just to everybody know, like so. Okay. Thank you.
Okay, thanks, Andy. So the next question is, in case my H-1B visa is denied, can I file 485 for my wife with my downgrade?
Yes, I mean, yes, they can file, but you have to understand this. If she's failed to maintain status in this country more than 180, at least for 180 days, then she may be ineligible to adjust status in this country under Section 245A and 245K, basically. Okay, so it's important that even if she fails to maintain status, even for 1 month, 2 months, if she files for adjustment of status, she'll be okay, because Section 245K provides an exemption from Section 245A. So very careful when somebody fails to maintain status in this country, how long they've been out of status in this country, they have to assess that timeline to file I-485. Especially if it's not an immediate relative petition. If it's an immediate relative petition and a family-based basis immigration petition, it is entirely different thing. Even if you violate status in this country, as long as you lawfully enter into this country, you'll be okay to adjust status. But other cases, we have to look into timeline, how long one has been out of status in this country to file for adjustment of status.
Okay, thanks, Andy. So the next one is, till what age can my kid be in my green card EAD before getting the actual green card?
I don't know what the question is. I mean, the question is very vague, very difficult to answer basically. I mean, as I said, if the kid is unmarried and if they file before 485, before 21 years of age, the kid is authorized, kid is entitled to get a green card, irrespective of what his age will be at the time he gets a green card, as long as he's unmarried. And as long as his 485 is pending, he is eligible to apply for an employment authorization document in this country and continue working in this country based upon the employment authorization document. So its question is very vague, but this is what the actual law, what a state is basically.
Okay, thank you, Andy. So the next one is, if my AP and EAD are received to my address, does that mean 485 is approved?
No. 485 is different from advanced parole and EAD. So
Okay. And the next one is, my current visa is an extension and I don't have a valid I-94. Will there be any impact for 485 filing?
no. No.
Okay. So this is a little lengthy question. He says, sorry about the lengthy question. My 140 EB2 priority date is 2012 June. I was hired in California and 140 was filed and approved in California. I moved to Arizona in 2017 with the same employer. My payroll is running from Arizona and company head office is in California. Should my company file a new 140 with Arizona location, as a roving option was not specified when filed initially in California? Is it suggested to ask my employer to file a new perm with EB3? Can I keep my old 140 from California when EB3 is getting filed?
Yes, basically, just a second. My battery is going down. Just a second. Sorry for that. Why it's going down? Battery, everything is charging. Oh, that's why. Okay. Sorry for that. My laptop battery was going down. Sorry for that. And see, the point here is this, basically is this. If the principal place of business is California, then the company can file green card only from that location. They cannot file from Phoenix, Arizona location. Therefore, that I-140 is valid and they can actually file 485 based upon that if the company is still intending to hire him in that location, basically, after getting the green card. So that is what is there. If the principal office is in Arizona, if it's not a branch or affiliate in Arizona, they cannot conduct recruitment in Arizona for filing a green card. Simple thing is that. Okay, it does not matter where he works, whether he works in California or Arizona, as long as the recruitment is properly done in California, and if they intend to hire him in California location, once he gets his green card, they can actually file 485 based upon that I-140 petition.
Okay, thank you, Andy. So the next one is, my current visa is an extension and I don't have valid I-94. Will there be any impact for I-485 filing?
No, we repeated. I think it's a repeated question. We actually answered this one. So no.
Does filing 485 itself at the right time assure the primary and dependents get EAD, or is there any USCIS approval required before getting EAD?
I mean, EAD has to be approved, right? Without approval, you can't. I mean, EAD application has to be approved. Sometimes EAD applications can be denied if you don't file it properly, or if you're not eligible for EAD. Obviously, EAD applications has to be approved. They're not independent. They're not like you just file EAD 485. You're not going to get an EAD. You have to apply for an EAD application. You have to file an EAD application, and you have to prove independently that you're eligible for EAD because your 485 application is pending with the USCIS. If you don't prove that, then obviously EAD application can be denied.
Okay, thanks, Andy. So the next one is, how long will it take to get the EAD after applying downgrade EB2 to EB? He says EB2 to EB2. I don't know if that's right.
Basically, I'm assuming that he's talking about filing EAD along with I-485, along with the downgrade I-140 from EB2 to EB3. If that is the case, basically, when you file I-485 along with the EAD application and everything, once EAD is receipted, as of current scenario, I'm expecting at least 5 to 6 months.
Okay, thank you. I'm in EB2 I-140 approved. My priority date is Jan 2013. Furlough affect my current job. Now for my new employer, what will be the best option? Do I need to downgrade to EB3 or continue with EB2?
I'm sorry, this question is not clear at all. I mean, who furloughed, basically, who's your employer, who filed your I-140? Is it the same employer or different employer? I'm completely confused, basically. Yeah. So I don't know how to answer that question.
Okay, so we need more information.
More
So
information.
moving on to the next one, Andy. So how long will it take to get the EAD after applying downgrade EB2 to EB3?
That's what I'm saying. That's what the same question I answered just right now.
Oh yeah, sorry, it's a duplicate.
Yeah, yeah.
Do we need to have prior employment experience letter or an affidavit is acceptable?
It all depends upon, I don't know how to answer that question. I mean, it's very specific point, basically. Why do we need an experience letter, first of all, in the beginning? If the experience only comes into kick-in position, basically, if the position requires experience, and you need to show that you qualify for that position based upon the experience you had in your previous positions, basically. That depends upon how I-140 is drafted, or how I-140 is prepared, or what are the requirements for the I-140 labels it, what are the requirements for the position, everything. So it's very difficult for me to tell. You know, affidavits, if you cannot get a letter from the employer, obviously you have to get only the alternative is for you is getting an affidavit from the manager of the employer who can basically attest your work experience, or at least 2 employees along with the manager basically giving an affidavit attestations that you actually worked in there in that position, everything, providing the peoples who are actually giving those affidavits their contact information and how they know you and everything. Those are the requirements are there for the affidavits basically, and the experience must show progressively responsible experience. That's entirely a different topic. I don't think this is not the topic. This is not the call which we meant for the topic basically, you know.
Oh. Thanks, Andy. So the next one is advanced payroll extension like H-1B application, or is it common like H-1B where it gets denied often, relatively speaking? So
advanced payrolls usually will not be denied if you properly file it. It's all about properly filing, and as long as you show that you have I-485 pending and you never violate any status or anything like that, your advanced payroll will not be denied.
okay, thanks, Andy. So the next one is, does the college accept kids with green card EAD for in-residence fee and not international student?
That I don't know. It all depends upon the state to state. But 90% of, I mean, as far as you know, most of the states do accept them as a institution fee. In-state, they do consider for institution fee for those kids.
Okay, thanks, Andy. So the next one is, how can I maintain the non-immigrant status in parallel along with adjustment of status pending? I heard if you enter into country with advanced payroll, you lose your non-immigrant status. Also, Is there any risk for travel abroad with advanced payroll?
No risk in traveling on advanced payroll abroad. That is the first thing. Yes, it is true that if you travel on advanced payroll, you lose your immigration status basically. Because you're entering into this country as a parolee based upon your adjustment of status application is pending. Okay, so you'll be, in order for you to work at the time, you need to have a valid employment authorization document. Okay, if you want to maintain non-immigrant status, then you always have to enter pursuant to the non-immigrant visa in your passport into this country.
Okay, thanks, Andy. So the next one is, my place of birth is different in birth certificate and my passport. In this case, do I need to provide an additional document?
First of all, why there is a difference in the birth certificate and the passport? First thing is that I wanted to know, is there intentional misrepresentation or some mistake happened at the time when they applied for the passport, basically with the birthplace. Second thing is basically is that under those circumstances, I would not submit birth certificate. I would not advise them to submit birth certificate basically. Okay, try to get a non-availability certificate and submit the information properly. Or if the birthplace in the birth certificate is correct, then basically make sure that make a correction to your passport and explain the mistake happened in the passport and submit the birth certificate and everything. That's correct. If the birthplace in the passport is correct, then don't submit the birth certificate. Try to get the corrected birth certificate if you can, or then get a non-availability certificate and submit the affidavits and everything. First of all, why that mistake happens, I do not know. It's basically beyond my imagination. Sometimes it does happen, but that should not have happened in the beginning, basically.
Thanks, Andy. So the next one is, in the 485 application, if the derived has an approved I-140, but their date is not current, what alien number should be used for the derived application?
If there is an alien number, you can use either one of them because they're going to club either one of the A numbers, basically, right? If there are two different alien numbers, and it's important to notify the USCIS while filing the application that the alien has two alien numbers and they have to club both the alien numbers into one. Sometimes what happens is USCIS might create a new alien number by clubbing the two old A numbers into one file, basically. Or sometimes they may accept either one of those alien numbers and then club in that way also. So it's better to notify the USCIS basically that alien has two alien numbers basically when they file the petitions or applications.
Thanks, Andy. So the next one is my father's first name is my last name, and he's a green card holder. His last name is different in all three of my passport, his first name and my birth certificate. What can I do about it?
How it is different, I don't know basically. I mean, I need to talk to him privately. Very difficult for me to answer here.
Okay, thanks, Andy. So the next one is, since I'm filing based on EB3 December 2013 priority date, do we need to do medical exam now or wait until final action date?
It's always preferred to submit medicals in the beginning, but if you cannot do it because of the COVID-19 situation, if the doctors are unable to schedule you timely within October 1 to October 31, it is okay, you file 485 without medicals, you'll get an RFE from the USCIS sometime. Whenever you get an RFE, go and get the medicals done and then submit them to the USCIS.
Okay, we have just a few more. And the next one is, can I send 485 documents to physically to Phoenix USCIS office location, or it should be mailed?
I'm sorry, I didn't get your question.
He says, can I send the documents, 485 documents to physically to Phoenix UCIS?
I don't know. Depends upon where you are located. I mean, it could be the Texas Service Center, it could be Phoenix, it could be, Nebraska. Depends upon where you're located. Very difficult for me to answer that question.
Okay, thanks, Andy. So the next one is this new fee of $2,270 for AOS bundle?
Yes, I think it's 2261 or 2291, basically for the I-485, I-131, and I-765. There is no biometric fees for the I-485 filing now.
Thanks, Andy. And I think this is the last one. Is the credit report will verify after receive the EAD as well? I don't know. Is credit report will verify? I think will credit report be verified after EAD is received? My priority date is current and I received EAD in 2012. Does credit report impact green card?
Yes, USCIS may ask everybody to provide self-sufficiency form in the future after October 13, 2020 for the cases that are pending with the USCIS while the adjustment of status application has been filed or anything like that. But I need more clarity on this question. Yes, USCIS may ask you to provide self-sufficiency of you showing that you're not likely to become public charge, basically.
Okay. I think there's only one more question, Venkat Garu, so we read that or?
Yeah, so before that, to answer that, first and foremost thing is, Bhanu Garu, thank you so very much from the bottom of my heart.
It's my pleasure, sir.
We just asked yesterday and then you accepted and then you came here and then you answered almost 60 questions. So, which is, I think just it is very well organized. For that, Rupesh and Radhika Shiva, Srinivas Gottipati and Ashwin. So all these four people, they were managing everything well, very well organized with all the questions and then asking the questions. So I think it is pretty good. Thank you so very much for each one of you. And also, this is BBI Law Firm. So
it's BBI Law Group. BBI Law Group.
Yeah. Law Group. Yeah. Okay. So you can search that internet and then please reach out to Bhanu Garu and then if you want to take the appointment. And I think Bhanu Garu, I'm receiving a lot of feedback already. So it is so useful to the people, right? So, and everyone, I have given my cell phone number in the chat. Please text me if you want to receive the recording of this. And so that way, I think just we don't have to repeat the same questions, because he answered a lot of valuable questions, and just you can be able to listen to that. Okay. Thank you, Bhanu Garu. Thanks so very much.
If we have Bhanuji's number, can we put it in chat for everyone?
Yeah, sure.
So that if they so if they need him to contact the law firm directly, they can do that.
Absolutely. Absolutely. Please do that, And my office number is 703-496.
1 minute, hold on. Yeah, 703
496 7722. That's my office number. And my mobile number.
That is good enough for you.
Yeah. Thank you.
Good enough. Yeah. I think okay. Let's stick to that, and then if we really need, I think yes, we'll share that mobile number here.
Yeah. Thank you.
Yeah. Okay. So Rupesh, you got that number, and you got their firm number as well, right?
Yeah, I have. Venkatji, I have put that in chat for everyone. So if they need to contact Bhanuji, they can contact.
Yeah. Okay. Very good. And then next one is like go ahead, Radhika Garu, just ask the question.
So they last Ochi. So he says, I'm eligible for downgrading and filing for concurrent 140-485. I have a H-1B visa appointment on October 15. Should I file my 485 before departing to India or after arriving back with a valid visa? In case of visa denial, can I file from India for my wife at least?
No, file it before you depart to India. File it before you depart to India, your I-485s for you and for your spouse and everybody basically, And then once you file it, because you're in valid H-1B status, you should be able to travel abroad, get visa stamped, and then come back, My point is, if the worst case scenario, if your stamp doesn't come, your advance parole has to come for you. Probably it will come for you, basically, okay? Because you filed while you are in valid H-1B status. I would advise file it before you go, because we don't know when you're going to come back. And what if dates goes backwards at the time and you cannot file your adjustment of status application,
Okay, so Bhanu Garu, so one small request, and so like we have the last minute questions, like 2 or 3 max. Sure. So let's finish that off as well. So Radhika Garu, go ahead.
Sure.
Okay. Thank you so much. So I wasn't sure if we have the time. So is advanced payroll document and EAD enough to maintain status until we receive green card, or should I maintain my H1?
It is okay to be an adjustee in this country. You don't have to maintain H1B while you're present in this country, while your adjustment of status application is pending. But if you can maintain H1B at the same time, there's nothing wrong with it. It's actually, it's a safe method, because what in worst case scenario, if your 485 gets denied, at least you have an H1B status in this country. So if you can maintain both, I would advise to maintain both. If you cannot, it's okay. Now, you don't have to worry about it, but it's always better to maintain both if you can.
Oh, thanks, Andy. So the next one is, do we need to submit any supporting documents if the birth certificate is recent, meaning registered last month?
If it's registered last month, yes, they have to submit the affidavits, basically, because the date of registration is very, very important for the birth certificate to be valid. If the date of registration shows within the year of someone's birth, then that is absolutely valid. Otherwise, if the date of registration shows very recent, then they have to attach the affidavits along with the birth certificate.
Okay. Thanks, Andy. So the next one is, my PD is July 2014 and my husband PD is September 2015. Can we file 485 based on my PD, and can we resubmit resubmit 485 again based on my husband's PD?
Yes, absolutely.
Okay, and this is the last one. If we file 485 and 765 together without medicals, can USCIS process and reissue EAD card? Or to issue EAD card, medical is mandatory?
No, for issuing EAD, medical is not mandatory. Medical is mandatory for adjudicating 485 application, basically. And yes, you can file them right now. And as I said, if you file without medicals, it's likely that you get an RFE for your 485, requesting medicals, and you can submit medicals at that time.
Thanks, Bhanu Garu. That was all the questions. Thanks, Andy.
Thank you very much, Radhika Garu. You've been wonderful, wonderful. What do you call host? I would say basically you've been wonderful asking questions, And Raj Garu, you're also been great, Andy. Rupesh Garu, you've been wonderful, and everyone, Venkat Garu, Srini Gottipati Garu. I mean, I don't know. I would say thank you very much for giving me this opportunity all the time, and I'm glad. I hope I have helped. I've clarified many people's questions in this section. And if they have any other questions, please ask them to feel free to reach me anytime. I'm very happy to clarify their doubts, And,
okay. Thank you so much, Bhanu Garu. Thank you. It is little late for you.
Thanks a lot.
That's okay, sir. That's okay, sir. It's understandable. Every day we don't do this. We only do this when it's needed for the community. And I think it's very much needed for the community right now. That's why people like you. We want to see people like you in national level, sir, just not in Phoenix area, You should start campaigning at the national level, and being a GOP member, I'm very proud of you on that way.
Absolutely. Yeah. Okay.
Thanks a lot, Bhanu.
Thank you, sir. Thank you, sir. Yeah.
Okay. Thank you, everyone. And Radhika Garu, and then Rupesh, and then Ashwin, Srini, and everybody joined. And so send me the text message so that way I think we can share that link as well. So, okay. Thank you all.
Thank
Bye.
you all.
Thank
Have
you
a
so
good
much.
night.
Thank
Bye.
you.
And please stay safe
Bye.
and stay healthy. Thank you.
Thank you.
Okay.
So much.
Thank you.
Bye.